All right, back at the CBO Technical Assistance Call, we have a special presentation today from Beth Johnson, who is with the Cabrini Green Legal Aid Society. She is the Director of Legal Programs, and today she's going to be doing a special presentation for us on working with criminal records. So thank you, Beth, for joining us today.
Hey, my pleasure. One of the problems I have, though, is because I'm sharing my screen, I can't see if any questions are popping up. Because
We'll get those for you. We'll get those for you.
All right, cool. So this presentation is uploaded on that shared files thing on your fancy platform that you all use. And I did attach some other shorter reference documents for you to be able to walk away with that I'll reference as we go throughout this presentation. But really, this is the goals of what we're talking about today, how to know what's on somebody's criminal history, how to know the options they have available for relief from their criminal record, knowing their legal rights, and knowing what to say, because as you might already know, the majority of people don't qualify to expunge their records, right? So we're dealing with people that will still have publicly available records. So what do we say when we're applying for jobs and housing and education? And so this is the goals of what we're doing. So I'm going to be starting off with criminal records themselves, the creation of criminal records. So a criminal record comes from two sources, both the police, who arrest you, and the court, who processes you. Whenever we're determining what's on somebody's record, we're looking at a combination of those two sources. So this is kind of the trajectory of an arrest that happens, right? There's a decision point right in the beginning whether or not somebody is released without being charged, when they don't go to court at all and their case ends there. And if they are charged in court, it's another branch again. You're either found guilty or the case is dismissed. If you're found guilty, you can either be convicted or receive a sentence that's not a conviction. And so this is a process of how a criminal record is created, and I think the entry point of the arrest, it's good to understand that that is the record itself, a mere arrest. It can be on somebody's criminal record. So one way to find out what is on somebody's criminal history, for the organizations that are located in Chicago, CPD has a rap sheet generating machine down at 35th and Michigan where they take fingerprints daily. Just so everyone knows, a rap sheet stands for a record of arrest and prosecution. So that's where that comes from. So how somebody gets a rap sheet, an individual themselves has to obtain a rap sheet, whether it's from Chicago or from the state police that I'll talk about in a moment. It can't be accessed even by somebody's lawyer. It has to be accessed by them themselves, requiring fingerprints to have it happen. This is a cost that cannot be waived, so oftentimes this could be a barrier for people, in addition to the fact you can see at the bottom it requires 2 trips. You go one morning to get fingerprinted, and they make you come back a week later to pick them up. But why is it critical to know about a police record? It's the record of every time there was an arrest on somebody's background for us to account for in determining what they're eligible for. Because the most important thing when you're applying for jobs is being able to know accurately what's on your background, right? Because if you can't answer that, you can't dispute it. You can't address it. So this is great for Chicago people, right? But I know that some of the organizations are not located here. So there is a new process that became effective July 1st of 2015 where you can access your Illinois State Police statewide background check. So the ISP has always provided people a record of their convictions. What this change in administrative rule did was allow somebody to obtain a copy of all arrests and convictions that happened in the state of Illinois that the state police know about. The beautiful thing is if you're going to get your Chicago rap sheet, you can request one of these as well for no additional cost. And you can also request this ISP, Illinois State Police, statewide background check from any law enforcement agency. I included the rule here so you can give to people because historically Before July 1st of 2015, they were prohibited. They weren't allowed to give somebody a copy. So anytime a change takes place, it doesn't mean that everybody's on top of the administrative rule changes that happened, you know, down in Springfield. So this is where individuals can access their Illinois State Police background check. If they have a record in Chicago, you might as well get both rap sheets. They're the same cost. You have to ask for it. And if you're outside of Chicago, you can go to any local law enforcement agency and request your ISP statewide background check. And it's very important to get that, again, to know what is exactly on record with the state.
Beth, I have a question to maybe help clarify this a little bit for our downstate people. Do local law enforcement agencies have a rap sheet like Chicago has a rap sheet? So could they then get their local and their state?
No, it is unique to the city of Chicago. Other municipalities, even in Cook County, don't have that same thing. I'm not sure if it's because of the volume of people's records. That's actually a great question. I'm not even sure when rap sheets have started. I've been doing this work 11 years now, and it's just always been. But no other municipalities have their own. You would have to ask them for individual arrest reports. But to ask them for individual arrest reports, you have to know the dates you were arrested. So it's kind of a catch-22 people found themselves in. And which is why it's such a huge advancement that you can now get your statewide background check. And if all your cases are in one county, McLean County, let's say, they should all be listed there.
Great. Thank you very much.
Okay. And so after you receive your police records, as we talked about in the very beginning, you need to know what actually happened in court. So that's your court records. And these are the two avenues that happen when somebody is charged in court. You either receive a conviction or you receive a non-conviction. So I think the main takeaway from this screen is it's not the finding of guilt that means you're convicted. It's not a judge saying you're guilty. It's not you pleading guilty. It's the sentence you receive that determines whether or not you've been convicted in Illinois. So on the left-hand column, any one of these sentences, jail or prison, probation, conditional discharge, those are all convictions. If you're found guilty or plead guilty and receive one of these sentences, those are considered convictions. On the other side of the screen, on the right side, the bottom four boxes, supervision, 710, 1410 probation, task probation, these are all instances where somebody's found guilty as well. They're found guilty by a judge or they plead guilty, but these sentences in Illinois, if they're satisfactorily completed, are deemed not to be a conviction under our laws. And of course, dismissals, acquittals, release without chargings, those are all non-convictions too because you were never even found guilty. So the biggest barrier people encounter in terms of non-convictions, in addition to unlawful discrimination because of dismissals or acquittals, is the fact, what does an employer see when they run a background check? The fact somebody's found guilty. They're not aware that the legal definition of supervision means you're not convicted. And so it's very important that even when people don't have convictions on their background, they have these other sentences, that they do something to remove them from their record. So these are the two buckets that dispositions fall into. And a disposition is the end result of a case. A person has to account for every disposition on their record to determine whether or not they have options. The best option that somebody could undertake is to expunge or seal their records. And the reason that is they actually remove them from public view, right? So when a background check is run, it comes up no record. For people that aren't eligible for expungement or sealing, and mind you, we see about 6,000 people a year with criminal records, only 36% of the 6,000 every year, it's consistent every year, can fully expunge or seal their records. That means 64% of the people are falling on the right side with ineligible convictions, and these are some of the options that are available for them. Clemency, which isn't a great option, which I'll talk about, health care waivers, and certificates of rehabilitation. So every single arrest and disposition of that arrest, again, the disposition being the result from court, determines what bucket you fall into. And that's why it's so critical to know what's on your record, because without it, you can't know what options are available to you. So expungement and sealing. So anyone that's met anyone that has a criminal record, what is it they want to do? They want to expunge their records, right? Because who wouldn't? Who wouldn't want to have your record and your past be removed from public view and no longer be a barrier? But as you can see on the top right, expungement is only available if you've never been convicted at any point, anywhere in the world. And I say that facetiously, but if you have all dismissals, let's say, in Cook County, but you've been convicted out in DuPage, you look at your entire record, and because of that conviction, you can't expunge. You would have to look if you're eligible for sealing. So expungement is only for those who have never been convicted. Sealing was the remedy that our General Assembly came up with in 2003 was the first time. So for the first time, somebody with a conviction had an option to go to the court to be able to petition the court to remove their records from public view. And it really did open up a lot of relief for people. Because before that, no matter how minor your conviction, you couldn't expunge. That was the rule. But the only option you had for even the most minor of convictions was to get a pardon from the governor. And that's a bunch of hootenanny to go through a process for a criminal trespass, a misdemeanor conviction on your record, for example. So I'm going to pause real briefly because the law is changing coming up in January. For the first time, this top right, expungement is only available if you've never been convicted. That's been around since 1930. That's how old this law is. Expungement's only if you've never been convicted. What the law is changing to say come January is that you can expunge anything that's not a conviction, and you have to seal any eligible convictions on your record. So we're going to have some information because we're going to have to start educating the public and our partners about this change in the law. And we'll make sure that we get it to Tammy and Dee and others that they could share it with you when it comes a little more relevant. But these are the two main ways to clear your record. And the biggest difference between these two remedies, expungement and sealing, is who has access to that record. Records that are expunged are physically destroyed by law enforcement. So when you get pulled over in the future, the police don't even have a record of that. Allegedly, right? That's what the law says has to happen. There's no doubt that the law and reality don't always match. Sealed misdemeanors, so the difference there is that they're only available to law enforcement, but nobody else has access to them. Sealed felony convictions are also available to law enforcement, but this is the big difference with sealed felonies. They're removed from the general public view. No private entities have access. But any employer that's authorized by law to conduct a fingerprint-based background check will always have access to a sealed felony conviction. So an employer that runs a fingerprint-based background check is running it through the state police. The state police is one of the entities that's expunging or sealing the records. They're still allowed to release those. So some common examples: schools, park districts, healthcare. If you had 20 cases on your background, 19 misdemeanor convictions, and 1 felony, they were all sealed. If you went to apply for a job at the school would still see the sealed felony conviction, but not the sealed misdemeanors, the 19 of those. So this is the difference between the forms of relief. Why someone would expunge versus seal is determined by what's on their record, and the relief is the access afterwards. A main point here is that an individual who seals a conviction is lawfully allowed to answer no to a question about whether they have a criminal record. That's why you're doing it. Because we all know now, if you have a conviction and you say, no, I've never been convicted, that could be falsifying your application. That could remove you from the applicant pool. So that is why people pursue this form of relief. So here's some expungement and sealing eligibility. So it's all about when and what can be expunged and sealed. So the law defines when. When is a waiting period when a record can be expunged or sealed. Something to note, a person with a pending case cannot file a petition at that time. They have to wait till all cases are over with. And the law imposes that waiting period. So I'm going to go a little more into those in a few more slides. And then the law defines what can be sealed, which offenses can be expunged or sealed, both in terms of if it's expungement or sealing or whether or not it's an eligible conviction. So I'm going to break this down just a little bit. I'm confused by this slide. I borrowed a presentation today. All right. So everything on somebody's record, if they're sealing, can be sealed if it's a misdemeanor unless it's one of these. So every misdemeanor conviction is eligible for sealing unless it's one of these. And this is a very short list compared to what it used to be. So domestic batteries are ineligible. Violations of order of protection. Any of these quote-unquote sex crimes under Article 11. Soliciting a prostitute, patronizing a prostitute, public indecency. Note that prostitution is eligible for sealing, so it's not included within this exemption. And then any offenses which are against the public morals, because we didn't know how else to define them except, drunk driving and dogfighting. So these are the offenses when it's a misdemeanor, aren't eligible when you've been convicted of it. So please note that any case that results in a dismissal or an acquittal is eligible. These exclusions only apply when you are actually found guilty and convicted. So what misdemeanors are eligible, you might think, like as a comparison? Theft offenses, prostitution, trespass, simple battery and assault. Any other misdemeanor offense that's not listed here is eligible to be sealed. So the reverse mentality applies when you're talking about felony convictions. So there's like 1,000 felonies on the books, no joke. 9 are eligible for sealing. So that sounds dire, right? But note the stars that are next to the ones on the bottom. Before 2 years ago, those weren't eligible. We only had 3 felony convictions. Possession of controlled substance, prostitution, and possession of cannabis. Those were the only eligible felony offenses for about 7 years. With Advocacy down in Springfield, finally the sealing law was expanded to include these other lower-level, quote-unquote, felony convictions. So if you were convicted of any of these felonies, you are eligible to petition the court to seal that after the appropriate waiting period. But there's a lot of felonies that don't fall within that category, right? I mean, I'm sure you can think of convictions you've seen that you're not seeing on this list. Burglaries, selling drugs, not just possessing them, but selling them, any of the higher class felonies, any sort of violent crimes, any sex crimes. So this is what I meant in the beginning when not everyone is eligible to clear their records through expungement or sealing. We can't minimize the fact that this law does help many people. Like literally hundreds of people do still seal their records each year, but there's also a larger pool of people that just don't qualify. Something to know, so here's some waiting periods for when you can seal. Really, I think the bottom one's the most important. Whenever you're looking at sealing convictions, it's 3 years from the completion of the last sentence. You see it says effective January 1st of this year. It used to be 4 years. So it went down a year in the wait, which doesn't seem significant, but I see it as progress, right? 4 years is a long time. 3 years is a long time too, still, don't get me wrong. But it's better than 4. So a person, if they're serving a sentence, the waiting period starts from the day they complete their sentence. Terminated from probation, discharged from parole. Dismissals and acquittals have no waiting periods. It's only when you're actually found guilty that you have a waiting period imposed on you. This is a really exciting development that happened again this year, is that effective January 1st, if you receive a degree, a diploma, a certificate, a GED, while serving your sentence, while you're on probation, while you're on parole, while you're incarcerated, you can negate the waiting period to seal eligible offenses and be immediately eligible after you're done with your sentence. So again, this was a very recent change in the law. It's only been about 9 months. And the law is kind of vague, right? Like, obviously, we all know what a high school diploma is and a GED and associate's degree. But what in the world is a career certificate, right? What's a vocational technical certification? A lot of this is untested and ultimately would be up to a judge. But the reason this is important is somebody could cut 3 years off their wait if they obtain something while they are serving their sentence.
Beth, you said something earlier about the case and if they've never been convicted before. In some situations, somebody who's being convicted of something and being sentenced for something, there's normally more than one count. What happens with those kind of opportunities?
So we look at what the finding of guilt was actually entered on. So let's say that you're charged with burglary and possession of burglary tools. I'm going to go back a couple screens.
Okay.
The case is going through, right? You're found not guilty of the burglary or the state dismisses it, but you're found guilty of the possession of burglary tools. That's a great outcome because look at the last offense on this record that's eligible to be sealed, possession of burglary tools. And if the burglary is dismissed, then you're fine. But let's say you were found guilty of the burglary too. That would make that entire case ineligible for relief. If you're found guilty of a count within a case that's not eligible, that entire case is removed from eligibility.
Okay, that clears up my question.
Okay. So I didn't put a lot of detail in here about filing petitions and things like that, but just some 3 high-level points. The first is you have to file in the county where the case has happened. So if you have a case in DuPage and a case in Cook, you got to file 2 petitions. The second point is that fee waivers are available in every jurisdiction. If you are at 125% or less of the poverty level, federal poverty guidelines, you can have your fees waived by the court, so that should not be a barrier for somebody. But mind you, this is something that we need to educate the people we serve about because the clerks aren't willing and readily able to tell. They don't tell people that information all the time. And a lot of time there's a myth out there that I have to pay hundreds of dollars to get my records cleared, which might be true, but if you're not working or you're unemployed or underemployed, that will not be a barrier because fees can be waived. I think I said 2 things already. So yes, you must file in the jurisdiction. You can have your fees waived. And relief is never automatic. It's always discretionary. So the judge doesn't have to, even if you're completely eligible to expunge or seal your records, the state's attorneys are present in these proceedings and they can object. A judge could object and decide not to seal your records. So these are the things that they look at. The circle that goes around the relief is always discretionary. The strength of the state's case. So what does that mean? If I'm charged with murder and my case is dismissed or I was found not guilty, that's eligible for expungement if it's the only case on my record. However, I could have been found not guilty because I was actually innocent, or I could have been not guilty because of a technicality that happened in the proceedings. The judge in the state is allowed to look at what underlying happened, even when the case resulted in an acquittal or dismissal. Judges look at educational and employment history. They look at what would happen if they didn't grant it, right? So often we're advising people to go to court. Make sure that you're telling the judge why you need these records sealed. What jobs have you been denied? What barriers have you encountered? And of course, the judge looks at how long it's been since the offense happened or the last offense on the record. And so just like the laws the laws are very black and white. Your offense is either eligible or it's not. But everybody has a story behind their record, right? And this is a chance when you actually go into court to talk about that stuff. If the relief is granted, records are removed from public view, as I mentioned. You can answer no to any questions, follow-up questions about whether or not you have a record. And that's the ultimate form of relief that somebody can get. This next part here, I don't know if you can really see it. My copy doesn't look so great on my big screen. So often people, and you might encounter this, I don't know, often people don't think their juvenile records are going to be an issue because in Illinois, juvenile records are automatically sealed, quote unquote. What that means is you can't go down to the courthouse as John Q. Public and run somebody's record. You can't go online and see somebody's juvenile record. But what this visual represents on the screen right now are all the exceptions to that law. These are all the people that do have legal access to see a juvenile record. The one that really does affect people in terms of employment would be DCFS. If you're doing any sort of employment in DCFS or child care where your juvenile record could still appear. The park districts is a really big one for young people. So the point of this is that although juvenile records are sealed, that seal is not very tight, right? Because there's so many people that can actually look at it. And so we're always encouraging people to explore their eligibility for juvenile expungement. Dismissed cases, supervisions, minor cases are eligible for expungement. Something to note, there's been a change in the law. You used to have to wait till you're 18 years old to be able to file. Come January 1st, the law changes, and you can file as soon as your case is over. You don't have to wait till you're 18 anymore, which is good. When you're found guilty and found delinquent on a juvenile case, the second box down there, you still can't file until you're either 21 or 5 years after the offense happened, and you can never have been convicted as an adult. This is juvenile expungement solely right here. So most juvenile records, almost all of them, are eligible to be expunged except for first-degree murder or a felony sex offense. Any other juvenile record would be eligible at a certain point so long as they've never been convicted as an adult. And that fine line between, adulthood and being a juvenile, that made-up definition that we have here in Illinois, it's very easy and quite often that kids are unable to expunge their juvenile records because of their adult record, which is a bunch of BS, right? Because if we're saying that kids should be able to expunge their juvenile records, we shouldn't take into account their adult behavior, but that's currently what our laws do. So this next section I'm walking into is about for people who are not eligible to expunge or seal, some of the remedies available. Is there any questions before we move into this section?
We have a couple, but I think they can wait until the end.
Okay. One other point, folks, that I forgot to mention is that partial sealing is an available option. So let's say, again, you have 10 cases on your record. 9 of them are eligible to be sealed. 1 is not. You can file a petition to seal the eligible offenses, even if some of them on your background are not eligible for relief. So it doesn't give you the full, full clear record, but what it sure does is minimize that record. So instead of walking in with 10 things on your background, you could walk in with 1, for example. So we encourage people to seal as often when they can because it's better to minimize the background. Okay. So these are the 3 main categories for people that cannot seal conviction records: clemency petitions, health care waivers, and certificates of rehabilitation. I have 1 slide on each of this. This is just a summary slide. Again, the PDF of this PowerPoint is attached, as well as a 2-page document for service providers to know about the different forms of relief, and a really good outward-facing brochure that can be used for people to explore the options. Because our main goal is if all we looked at was somebody's eligibility for expungement or sealing, we'd have a lot of disappointed people, right? Like I said, 64% of the people we see would walk out with a broken heart. We really need to be able to talk about these other forms of relief so people have hope that there is options, that they are going to be able to work, because as you all know very well, that's one of the hardest things with criminal backgrounds, is not just the denials, like the actual not getting of jobs, but the emotional toll it can take on an individual that's doing everything they can to lead a good life, right? So these are the main categories. No matter what category you fall into, a waiver, a certificate of pardon, these are the things you're trying to show to a decision maker. You're justifying what happened in the conviction, right? Proof of rehabilitation, quote unquote. So I say that because not everyone needs to be rehabilitated just because they have a conviction on their background. Sometimes it's just a dumb mistake you make. Sometimes you plead guilty to an offense that you weren't guilty of for other reasons. Sometimes you're wrongfully convicted. So we use that word loosely because we don't want to assume everyone was leading this terrible life that they had to be rehabilitated from. But that word is appropriate for somebody that was dealing with drug dependency or mental health that wasn't being treated, and the criminal record and arrests were a result of that. Rehabilitation makes a lot more sense. But despite the fact that we know the nuances between rehabilitation and not, judges don't. And they want you begging why you're a great person. They want to know about how your criminal history falls in your life history. Were you young when it happened? Were you older? Why did you do it? They always want to know about educational and employment history and why you need that specific form of relief. So it's the same song and dance that you do before different audiences, whether it's the court or the Prisoner Review Board or the Illinois Department of Public Health, whatever it might be. So how can you help in any of these processes? And even for the process of expungement or sealing when people go to court, provide letters of recommendation on letterhead that's showing the steps somebody is taking to do everything else to improve their employment outcomes outside of their criminal record, right? You can help compile and organize accomplishments or milestones in somebody's life. Some of the people that have the toughest time in court or before a board or preparing a petition of any sort is you might have a whole collection of these things, but to be able to pull out the most relevant for them. Accompanying a person to court or before a board when applicable, and I know not everyone's capacity allows this to happen, but this is things that can be done if possible. And of course, encourage and prepare a person for an appropriate career path. So let's say that when we talk about waivers in a hot slide here, you find out somebody has to wait to be able to get a health care waiver to work in health care. You wouldn't want them to be pursuing jobs in healthcare knowing full well they're legally not eligible, right? Because all they're going to be doing is applying for jobs that under the law they can't be hired for. So these are some of the ways that our social workers on staff, not that you're all social workers, I'm not saying that, but this is like what our social work team does for the clients we serve legally, and any workforce development partner can do. I know that Kara was on this call. This is something that we do in our partnership with them. They provide letters. The certificates that they give people are all evidence of somebody that they can use in the process. So clemency, I don't even want to talk about it because it's such a joke. It used to be a really viable remedy. A clemency is when you're petitioning the governor for a pardon. A pardon allows you to expunge an otherwise ineligible conviction, right? You prepare a petition, you go before the board, beg and try and prove that you're a good person, and the governor decides whether or not to grant it. So we got off a high of coming off of Governor Quinn. His grant rate was at 37%. So he granted pardons to 37% of the people that applied for one. Governor Rauner, although he's been making decisions, his grant rate right now is 3.8. So it's a very low grant rate. So this is what somebody, this is like the ultimate remedy you can get, but it doesn't mean that it's a viable one right now under this current governor. The one thing I can say that Governor Rauner has done is that he's decided so many petitions, basically by denying them, is that now the wait has gone from about 4 years. Somebody would file a pardon and not hear for about 4 years. Now the backlog is only 2 years out, which is good. You get a more timely response by 2 years. The bad part of it, it's not a very high grant rate at this time, but we can only hope that his grants will get higher, right, with more recently filed petitions. But this is the ultimate remedy for somebody to pursue to clear their record. Healthcare waivers, this is a really viable option for many, and I saw that some of the list of participants had healthcare forms in them, and you might be well aware of these already. Healthcare Worker Background Check Act prohibits unlicensed healthcare workers from working in healthcare facilities. There's a list of disqualifying offenses, property crimes and violent crimes and sex crimes. These are all crimes or convictions that we say bars you from working in healthcare. The waiver process removes that legal prohibition so an employer is allowed to hire you even with that conviction. Without that waiver, though, they're legally prohibited, right? So a waiver is for somebody to be able to get into healthcare facilities and be able to work even with a past conviction. And so unlicensed healthcare is anything from CNAs to home healthcare workers to food service and sanitation. If you want to work in the laundry at a hospital, you would need a healthcare waiver still because you're within the facility, medical records and billing. So these are good jobs. I mean, healthcare is a growing industry, as you all well know, and this is one way that somebody can get relief, even if they couldn't clear their records, would still be legally eligible to work. The Department of Public Health maintains a registry, and the waiver applications aren't so difficult. So I'm totally running out of time here. So this is the process for applying for a health care waiver. It takes about 6 to 8 weeks typically. Again, you have this PowerPoint available. The other thing that you can have, a person can do is go to court to file for a certificate of good conduct. What it does is it gives an employer immunity from negligent hiring. It can remove statutory barriers to employment. And instead of just saying, yes, I have a conviction, it's actually a court-ordered proof of rehabilitation. So right now, the Supreme Court is coming up with a statewide form to allow people to be able to file certificates in courthouses much easier right now than they are right now. Right now, it's basically you need a lawyer. It's an unfortunate reality. So once these statewide forms become available, this is a process that people can undertake to receive a certificate. And it's available for any offense except the very limited ones listed here. You have to go back to the court that convicted you to ask for one. You might ask, well, why did the sentencing judge give you a certificate? Well, that's what you're trying to prove, why you should be granted that form of release. And it's not, and judges retire and leave the bench. So, sorry to have rushed through that, but there is some good follow-up, and I have detailed packets on each one of those forms of relief. If you're interested, I'd be happy to send them on to be shared with you all, or you could email me too. So these are just basic things about Ban the Box. Does anyone, if you could reply real quick, is this something that we want to go over at all, or you just want to read this stuff? You know, basically employers can't ask anymore, have you been convicted, right? There's limited exceptions. If somebody does still ask that question, file a complaint. Make them stop. You know, it's a real easy online tool. This is a reference for you to do it. The thing is, and the city of Chicago has their own Ban the Box too. Really, Ban the Box is great in terms of not having that threshold inquiry be about your record on the application. But at the end of the day, no matter what, it doesn't prohibit an employer from looking at your record. It delays it, right? The question will still come. The question has to be tailored, right? They can't ask about arrests that didn't lead into a finding of guilt. They can't ask about expunge sealed records. That's under the Illinois Human Rights Act. No law says that you can only ask about convictions over, you know, under 7 years old, right? So a lot of times people think that, oh, they can only ask about my convictions in the last 7 years. That's not true. There's no legal cutoff in terms of how far they can go back. Title VII of the Civil Rights Act requires employers to do individual analyses in terms of looking at people. Doesn't always happen. And this is a point of advocacy. This is where you can help prepare a short, to-the-point response to the question about a conviction. Because even though they don't ask on the application, it's going to come down the road. Having someone be able to give a clear, direct response to, so do you have a background at all? We're going to run the criminal record now that you've been called in for the interview. To be able to respond, yes, I have a conviction from 1992 where I received probation on a Class 2 felony. In 2007, I was convicted of. To be accurate on what's on the record, and as well as be able to explain why you should still be hired, right? Because there's, you know, stories aren't that quick, but our job as advocates is to help get to the point so someone can talk about it with confidence and know what's on their record with confidence. Illinois Human Rights Act, you can go back to that. You can't ask about arrest or expunge or sealed records. And mind you, I'm a lawyer. I get it, the fact that these are the laws. It doesn't mean that stuff always happens. You know what I mean? But this is what the law says employers can't do. The Fair Credit Reporting Act, I think this is an important one. This Fair Credit Reporting Act doesn't just apply to credit reports, but also background checks. And why do we care about this? Is because background checks are the worst. They're inaccurate, they're incomplete, there's common names. So like my name, Beth Johnson, is in the Cook County system. They aren't my records, but the year and date of birth is similar, right? It's like a year before my date of birth and a month later. And so common names are a problem with background checks. Expunged and sealed records can still be released by bad background check companies. They can be duplicative, meaning they list the same arrest multiple times over and over, so it looks like you have 100 million cases when you only had one. And amendments or reducers are not reflected. So yeah, I might have been charged with burglary, a felony, but it was amended to a misdemeanor trespass. The background check says it's a burglary still, right? So the reason that this law exists is you're allowed to check the accuracy of the record because of all these problems that exist. All right. They have to have fresh information. So these are just things that, again, you can go back and review. Employers are not allowed to just start with a no, you have a record. We refuse to hire anyone with a felony. That's what the law says, right? That under Title VII, the Civil Rights Act, the disparate impact that has on protected classes on race means that employers are supposed to do an individual analysis, right? They're supposed to look at their state laws and consider whether or not they should hire somebody. They have to provide an opportunity for somebody to say why they should still be hired. Doesn't always happen. But if it does happen, this is where we can be good about it, and you can maybe work with employers so that they have a better understanding of what they should do with the criminal record. And there are referrals that we can provide to lawyers that sue these employers too, because sometimes they don't do what's right because of their morals. They do what's right because of their bank account. They'd rather not be sued. Okay. If you might meet sometimes people with convictions or arrests in other states, this is a great resource. It has the expungement and sealing laws for every state in the country, as well as other forms of relief. It's just an online resource to point people to. There's this wonderful website from the American Bar Association that lists every single collateral consequence of a criminal record. So if you know that somebody wants to be a nurse and they're moving to Indiana, for example, you could search Indiana laws about whether or not they're barred from nursing in that state. It's a pretty cool tool. And then these are different legal aid organizations in other states that might be available when needed. And so again, really quick, what can advocates do? And I use that term broadly. What can anyone do that's working with people with records? You got to know what's on somebody's criminal record. That's just the basic starting point, helping them understand as well as you, because when you're trying to place people, you got to know where they can and cannot go, and that's contingent based on their record. No records mitigation options. So that means expungement, sealing, waivers, certificates. Know the options that are out there for somebody. Know people's rights under state and federal law so they know their rights and can enforce them. The Fair Credit Reporting Act says you got to get a copy of your background check. If nobody knows that's a requirement, of course they're not going to get it, right? And they might have bad information out there. And know how to answer the question about what you can do, right? I have another one. Prepare a mitigation packet. That's always a good thing too, right, with the letters of support or explanation of the conviction. That can help people walk in to talk about their record with your support. Oh, and there is one more. Pursue legal relief when eligible, right? So there are pro se packets. Again, I'll make those available. Healthcare waivers you can do. You don't need a lawyer to do it. Sometimes you need a lawyer to help verify the records themselves. But this is the bad part. These are the only places that actually have criminal records programs, right? And 2 of them are online and not individual representation. And the last is us here in Chicago. So it's not like we have the whole state that's full of resources. I know primarily looking at the list of participants that primarily a lot of people are from Chicago, but if you're in these other counties and stuff, the Office of the State Appellate Defender has information. Illinois Legal Aid Online is actually a pretty cool website, not just for criminal records, but anything, and they have an online tool for you to fill it out. The fact that you can access Illinois State Police reports are real helpful because you can help people fill these out. The attachments on your online portal, or whatever it's called, has the help desk flyers for Cabrini Green Legal Aid to get help, as well as our numbers too. So that's that. I'm sorry I ran a little over. I know it's after 4 o'clock already, so I can end it there for now. If there's any questions that can be answered or any follow-up material, just let your people know, and your people will reach out to my people, which means me. I can provide it, and hopefully that will help you.
Thank you so much for this presentation. I do want you to just very briefly explain which files in the file pod below are part of this. So I believe there's a help desk flyer.
Help desk flyer, yep. How do I make this bigger? The AFR brochure, that's Alternative Forms of Relief. I can't open it up from here, can I? No. Oh, that's a download.
But it will open up into another file.
But everybody can. Anyone can do that. That's a nice summary of healthcare waiver certificates. This quick reference guide, thank you. This is something that's more detailed about, like, what's the form that you file a healthcare waiver in. It's just a reference guide on the alternative forms of relief. There's a basic expungement and sealing 2-pager that talks about eligibility. There's a flow chart that talks about eligibility for expungement and sealing as well. The basic expungement and sealing the number 4 there, it's numbered because of another reason, sorry about that, is a good handout for people. It's more basic. The flow chart's a little more complex, but people can follow it. It's just a way to determine if you're eligible. And then the 92816 training PDF, that's a PowerPoint we just went through.
Great. Okay, so that helps everybody understand what they need to download out of this file pod. I'm going to move it back down into the corner. And remember that if you click on the link and then try to download it, it will open you up to another screen. We'll leave the webinar open so that you can download these after we're done with the presentation. Does anybody have any additional questions? I do have a couple here, and Tammy may have to answer a couple of these for us. We have a question from Ron Ruffin and Eric Rebner that says, can we pay to get our clients' records sealed? So, Beth, just to give us a ballpark idea, what is the cost associated with expunging and sealing records, other than that $16 to get the records?
In Cook, it's $120 for a petition, or $135, excuse me, for a petition. DuPage, it's $216. That's the most I have heard of for an individual petition. You know, they used to make you divide the petitions by every case and charge you for each one. There's been a concerted effort throughout the state to stop that practice of robbing people. So, yeah, it could be anywhere from $135 to $200 if they don't qualify for the fee waiver.
All right. And then so Tammy, if you can answer, is this something that could be considered a supportive service cost?
That's something I've requested from our financial office, and I will get back with you guys and let you know that for sure, one way or another on that. One of the things I want to ask, though, you said the waiver, it's 125% below poverty level. They qualify for waiver of fees. Does that include all fees?
Not rap sheet fees, only any of the court filing fees.
The court filing. So that $16 is required regardless?
Correct.
Okay. Okay.
And it's
and I will get back with everybody to let you know on the cost.
I think it's 125% above poverty, right? Not below. I think I typed that wrong.
I don't know. Yeah, well, you know what I mean, right?
Yeah, yeah.
Okay.
All right. Well, we do have this presentation recorded, and we will upload this to the EPIC Partner Resource Guide. And if you have any other questions, Beth, do you want to share your email address in the...
Oh, yeah, email for sure. Don't ever call me because I'll never call you back. I'm the worst, but I definitely, emails are great. So it's my name, Beth Johnson, at cgla.net. cgla.net, Cabrini Green Legal Aid.
cgla.net.
Mm-hmm. Happy to answer questions, and we have enough of our team here that we can always split it, too. But absolutely. Because I know we went through that pretty quick, and, you know, it's hard when it's not live and blah, blah, blah. So.
Beth, I want to thank you so much for participating, because I know this has been a topic that a lot of our CBOs have talked about. You know, what the SNAP recipients are serving, it is definitely a concern. So we really appreciate having your expert advice on this topic.
My pleasure, people. My
and
pleasure.
I'm sure we'll be using your resources again.
Okay. Well, thank you so much. Appreciate y'all.
Have a great day. Does anybody have any other questions that we need to answer for you before we leave? All right. Well, all right. Alan would like Olivia to call if you can. So have a great rest of your day, everybody.
Thanks, everybody. Have a good one.